Hi, this is Zahour from Juror, and welcome to the Juror podcast on juror misconduct law, where our motto is, don't let juror misconduct taint your verdict. We analyze current state and federal juror misconduct cases and provide attorneys with strategies to identify, preserve, and advance juror misconduct issues at trial and on appeal. And today we're going to be looking at the case of Fairbanks versus State, which is out of Indiana. The issues we're going to discuss are suspected juror misconduct, the presumption of prejudice and the shifting of the burden of proof to rebut the presumption, invited error, and a juror's cell phone use, possibly to research police investigations and credibility on YouTube. Glad you're listening, because the only evidence you want the jury to hear is in the courtroom. Now let's take a look at Fairbanks versus State. Hi, this is Zahour from Juror, and in today's podcast, we're going to be looking at the juror misconduct issues in the case of Fairbanks versus State, which is out of Indiana. This case was decided on August 1st, 2018, and I'll be sure to put the full citation of the case in our episode description. Now, if you can, please leave us a review because we want your feedback and want to provide value to our listeners. And of course, if you were involved in a trial where juror misconduct was an issue, please contact us so we can interview you for our podcast. Now, the question we're going to answer today is this. Your law clerk sees a juror in the hallway looking possibly at a YouTube how-to video on police investigations and credibility. What does a party need to prove in cases of suspected juror misconduct to appeal his conviction? Here, we're going to talk about suspected juror misconduct and the presumption of prejudice and the shifting of the burden of proof to rebut that presumption, invited error, and a juror's cell phone use to possibly research police investigations and credibility on YouTube. First, before we get into the facts of the case, I want to talk about the presumption of prejudice when seeking a mistrial based on suspected jury taint. The presumption of prejudice exists if two requirements are shown by a preponderance of the evidence. First, there has to be some extrajudicial contact or communications between jurors and unauthorized persons that occurred. And second, that contact or communication must pertain to the matter before the jury. If those two requirements are shown by a preponderance of the evidence, the burden then shifts to the other side, or in criminal cases like this one where the defendant is appealing his conviction, the burden would then shift to the state to rebut this presumption of prejudice by showing that any contact or communications was harmless. If the state does not rebut the presumption, the trial court must grant a new trial. In this murder trial involving the disposal of an infant in a dumpster, the defendant was found not guilty of murder, but was found guilty of level 1 felony neglect of a dependent resulting in death. He appealed his conviction on several grounds, including juror misconduct. Defense counsel had reported to the trial court that his law clerk observed a juror in the hallway researching something on her cell phone about police investigations or credibility, possibly a how-to video on YouTube. Now, we never hear from the law clerk. This is just what defense counsel is telling the court about what his law clerk observed and heard about the juror in the hallway on her phone. The prosecutor also saw the juror in the hallway but did not observe cell phone use. Defense counsel reported that it did not appear that the juror was researching anything specific about the defendant or the case. Now, let's just stop right there. This is a huge admission by defense counsel. Why? Because if the suspected research did not involve the defendant or the trial, then the second requirement is not proven, and there is no presumption of prejudice in a suspected jury taint case. Since there's no presumption, there's also no shifting of the burden of proof to the state, and the defendant bears the burden of proving that juror misconduct or suspected juror misconduct denied him of a fair trial. The trial court asked defense counsel twice whether he wanted the court to question the juror, and defense counsel was reluctant to do so because he was worried about any ramifications on the defendant if the juror was questioned but still remained on the jury. He indicated he wanted nothing done at that time, and so nothing was done. Now, if we look at this from the trial court's perspective, the trial court is informed of possible juror misconduct, so it listens to the parties to start some sort of inquiry. Here, once defense counsel stated that the juror didn't appear to be researching the defendant or the trial, the court didn't have to do anything further, but it did ask defense counsel if he wanted the juror questioned, and defense counsel said no, so the trial continued and the defendant was eventually convicted. On appeal, defense counsel argued that the defendant was denied a fair trial due to juror misconduct, basically saying, hey, remember when I told you about that juror researching on her cell phone in the hallway? I think her actions denied the defendant a fair trial based on juror misconduct. Now, the Indiana Court of Appeals affirmed the conviction on the following grounds, and remember, we're only talking about the juror misconduct issues. First, at no time did the defendant ask for a mistrial based on juror misconduct. Since he did not do so, a presumption of prejudice due to suspected juror misconduct did not exist. Second, let's talk about invited error. Here, defense counsel was asked if he wanted the trial court to question the juror about the cell phone use in the hallway, and defense counsel declined. Since the defendant is claiming that the trial court should have questioned the juror, but it was defense counsel who rejected that option, the defendant cannot now benefit from the failure to question the juror about the incident. Finally, I want to briefly talk about the standard of review in juror misconduct cases. The standard is that the trial court abused its discretion in denying a party, here the defendant, of a fair trial in how it handled the juror misconduct issue. In order to get to the heart of the issue, we have to go back in time to when the juror misconduct issue was reported. At that time, defense counsel wanted nothing done and also didn't move for a mistrial. Since he didn't move for a mistrial, on appeal, he can't argue that the trial court acted inappropriately or abused its discretion in handling the juror misconduct issue because there is no ruling which is preserved in the record. A lot of times in these juror misconduct cases, a party is saying that the trial court ruled incorrectly and should have followed the party's suggested remedy. Well, here, in essence, the defendant got the precise remedy he requested when the suspected juror misconduct was reported: do nothing. He can't appeal from his own chosen remedy. So let's get back to our question, and maybe I'll rephrase it a little bit differently. Again, your law clerk sees a juror in the hallway looking possibly at a YouTube how-to video on police investigations and credibility. What does a party need to do in cases of suspected juror misconduct to appeal the conviction? First, report the incident to the trial court. Second, have the juror questioned or even possibly hear the law clerk who observed the juror researching on her cell phone in the hallway so that the record has evidentiary support to prove the two requirements by a preponderance of the evidence in suspected juror misconduct cases to establish a presumption of prejudice. Third, move for a mistrial or new trial with the request to question the juror or anyone related to the incident. The issue must be preserved on the record. Fourth, if that motion is denied, preserve the issue with possibly an offer of proof indicating what the juror and the law clerk would have testified to, showing that you would have met the burden of proof by a preponderance of the evidence to trigger a presumption of prejudice in suspected juror misconduct cases so that the burden would shift to the state to prove what the juror did was harmless. If the state can't prove that, you are entitled to a new trial. And that's it for our analysis of the juror misconduct issues in this case. If you like what you hear and want more, please subscribe to our podcast and leave us a review. And also, check out our latest CLE on juror misconduct called Facebook and Today's Juror, 2017's 10 Biggest Juror Misconduct Events, and use the code PODCAST25, that's PODCAST25, for $25 off our regular CLE price is exclusively for our podcast listeners. This CLE is accredited and or approved for 1.5 general credit hours in 30 states, and I'll put the link to the registration page in our episode notes. That's it for today. This is Nilgun Zahour from SM Juror, and remember, don't let juror misconduct taint your verdict. See you next time.